Hi everyone and welcome to episode 7. So in this episode I'm going to be completely upstaged by possibly the world's largest peonies. They looked pretty normal when I bought them in the supermarket and then they bloomed into these giants. Anyway, the first case that I want to discuss briefly today is the judgment of the Supreme Court in Dill on listed buildings, which was handed down on Wednesday. If you're interested in heritage and you'd like to hear about Dill in more detail, then David Alvin QC and Guy Williams, who acted for the Secretary of State, are giving a webinar on Tuesday the 26th at 11 a.m, and I put a link in the description below this video to the registration page for that. So Dill is concerned with a pair of 18th century urns that originally flanked the entrance to the gardens at Rest Park in Bedfordshire and were then moved to different properties several times between the late 1930s and the 1970s. They ended up in the gardens of a house in Warwickshire that had itself been Grade 2 listed in 1966, and in 1986 the urns and the piers on which they stood were separately listed. They were then sold at auction in 2009 for £55,000, and the local planning authority issued a listed building enforcement notice against the removal of the urns, which Mr Dill appealed. He argued that the urns and the pillars weren't buildings, but the inspector concluded that the status of the items as buildings was established by the listing, and he couldn't go behind that. The High Court and the Court of Appeal upheld the view that the status of the items as buildings wasn't open to challenge on appeal. The Supreme Court, however, has now overturned the Court of Appeal and has confirmed that an inspector considering an appeal under Section 20 or Section 39 of the Listed Buildings Act can consider whether or not something on the statutory list is a building. Lord Carnworth observes that a listed building is a building that is included in the statutory list, so if an item isn't actually a building at all, it doesn't become one simply by being included in the list. He also reasons that where criminal proceedings are brought for contravention of the provisions of the Act, it has to be open to the accused to argue that an item on the statutory list is not a building, and therefore not a listed building for the purposes of the Act. Similarly, under Section 39 of the Act, in an appeal against a listed building enforcement notice, the appellant can argue that the matters alleged to constitute a contravention of the Act don't actually constitute such a contravention. So again, the appellant has to be able to take the point that the relevant item isn't a building. The Supreme Court then goes on to consider what criteria are relevant in determining whether an item that appears in its own right in the statutory list is a building. There's an entertaining discussion of garden objects and structures. I have to say that I didn't know that the dinosaurs at Crystal Palace are Grade 1 listed. Lord Carnworth confirms that the Skerritt's criteria for identifying a building for the purposes of the Town and Country Planning Act are relevant to the Listed Buildings Act as well, so size, permanence and degree of physical attachment to the land. So that's Dill. Next I want to mention the judgment of Mr Justice Holgate from the 12th of May in a statutory challenge brought by the Mayor of London. The first ground of challenge was that the Secretary of State acted unfairly in determining an appeal by departing from the agreed approach that had been set out in the Statement of Common Ground, without giving the parties any notice that he had it in mind to do that, and without giving them an opportunity to make representations on the point. The ground was unsuccessful on the facts, but there's a really useful summary of the law in relation to departures by the decision maker from the position as set out in a Statement of Common Ground. It's also worth noting that on the facts, Mr Justice Holgate held that the Mayor ought reasonably to have anticipated that the inspector might depart from the relevant Statement of Common Ground because the appellant had itself resiled from it during the course of the inquiry. The final point to note is that the Mayor did succeed in challenging the costs award that had been made against him in respect of the appeal, so the discussion at the end of the judgment on that point might be of interest if you're considering challenging an appeal costs award in the High Court. The next case up for discussion is the decision of the Divisional Court, Lord Justice Coulson and Mr Justice Holgate again, from the 6th of April. Packham was a judicial review challenge that the TV presenter Chris Packham sought to bring against the Secretary of State's decision to continue with HS2. As well as seeking permission to bring judicial review proceedings, he also sought an interim injunction against clearance works in a number of woodlands. The aspect of the judgment that I think is interesting is the Divisional Court's conclusion that the application for judicial review hadn't been made promptly. The requirement under the Civil Procedure Rules, of course, is that the application must be made within 3 months and in any event promptly. The factual context is that the decision to proceed with HS2 had been published on the 11th of February, the pre-action letter was sent on the 28th of February, and proceedings were commenced on the 27th of March, so 6 weeks and 3 days after the impugned decision. The Divisional Court noted that the decision wasn't taken under the Planning Act, and so the 6-week time limit for judicial review of Planning Act decisions didn't apply, but the fact that the claim was made outside that 6-week period was one of the reasons that, in the Court's view, pointed to the conclusion that the claim hadn't been made promptly. The Court also referred to the fact that the 11th of February announcement on HS2 could have come as no surprise to anybody, in the Court's view, because it had already been heavily trailed in the press. Aspects of the challenge relied on material that had been heavily publicised and available to the claimants many weeks before the impugned decision had been made, and other aspects of the challenge could, in the Court's view, have been raised several weeks earlier than they had been. The Court also held that the delay was important because time was running out to undertake the works in question with minimal effect on protected species of birds and bats. So what I take from Packham is that where you're thinking of challenging a planning or environmental decision that formally falls outside the scope of the Planning Act, so that the 3-month period rather than the 6-week period for challenge applies, then if the writing was on the wall, so to speak, as to which way the decision would go before it was taken, and if you're going to be relying on material that was available to you before the decision was even taken, and if there are environmental reasons such as a survey or works windows that mean that time is critical, then you'd be well advised to get your skates on and certainly to file your judicial review claim within the first 6 months of the 3-month period. That said, the Divisional Court in Packham does acknowledge that the delay point hadn't been fully argued before it, so it's probably not the last word on the matter. Finally, before I sign off for this episode, the Supreme Court has refused permission to appeal in the Finney case, so it's now clearly established that Section 73 of the Act can't be used to change the description of the development in a planning permission or to impose a condition that would be inconsistent with that description. So that's everything for this episode. Thanks very much for tuning in and take care.